Welcome to Notable Approvals. 1 second, we're going to get started. Got to get Instagram off and going. All right. So, welcome to Notable Approvals. I am attorney Amanda Shaffer. We have another exciting case to talk about today. I'm trying a new layout here with this portrait mode, so hopefully you can see me the whole time. Before I begin, quick reminder, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video helpful or know someone who may, please hit that share button, that save button, leave us a comment, let us know what you like about the video. And if you need an attorney, our contact information today is actually scrolling across the top of the screen. We'll be happy to help. Give us a call, shoot us an email. As I said, today's case, I'm very excited to talk about. This was not an easy case to get approved. So, our client lives in California. She is a native and citizen of Israel who is initially here in the US on an L1A visa. And yes, an L1A visa can lead to a green card if your employer sponsors you. And that was her plan originally. The wait times are pretty long right now, but unfortunately, at the end of last year, she found out from her employer that they were going out of business and she was going to be laid off. And when that happened, she then had 60 days to decide what she was going to do. Either she was going to when you look at the options, there's unfortunately not too many when it comes to these work visas, but essentially, was she able to change her status, adjust her status, or was she going to have to leave the country before she went out of lawful status? So certain work visas, you have like a 60-day grace period if you do lose your job before your authorized period of stay expires. So we immediately got to work. And there's one thing I want to also mention about this. Oh, I was going to do little banners, but I guess I forgot about the banners. So one thing I want to say about this is that what's important to note is, when does your clock start? When does that 60 days start that you have to get something filed? So you don't have to have it approved within that 60-day period, but if you're going to stay in the US and either change or adjust your status, if you're eligible, you have to have it filed. They have to have it received within the 60 days. Now, what 60 days from what? It's technically, they say, your last day of employment, which is usually considered the date of your last paycheck. Now, sometimes people get letters from their employers that say the last day of work was May 7th, 2024, but your last paycheck was a month earlier. It's going to be your last paycheck, not what that letter says from your work. In several instances, the date that you receive severance pay can also be considered the last day that you were in status. You can use both. In her case, their severance pay was pretty much around the same time of her last paycheck, so we use the last paycheck. So very important, though, if you're in this situation, whether you are here on an L1A or any other visa status, work visa status, so I'm talking about those in particular right now, is to know if you do lose your job or you quit, how long you have, what your grace period is, and when that grace period starts and stops. So we decided the best move for her, since Israel is a treaty country, so we can do an E-2 treaty investor visa, is for her to open a company. Now, she could have also bought a company. However, the problem that we saw with that was that it takes time to close when you're buying something. And essentially, there was no guarantee she'd have the company within the time period needed. So we decided we were going to play off her strengths. What has she been doing all this time? Well, she does a lot of business development, fundraising, helping businesses with marketing plans, growth, profit optimization, that type of thing. So it's like a management consulting role. So we thought, hey, why don't you just do what you normally do, but you're with your own business? And so we decided, let's open a management consulting firm. Now, if you do, anyone who's done a little bit of research on this, or any Googling, will see that management consulting firms can be hard to get approved as E2s. And that is true, because not just anyone can do it. You have to really be a person who has that experience, number one, and of course, meet all the requirements, which we're going to get to now. So, the first requirement is that the investment is in a bona fide enterprise and is not marginal. Not marginal means that the income your company is going to bring in, or brings in if it's already started, is going to be more than you need to support yourself and any family members that may be dependent on you. The amount of the investment is going to depend on the type of business that you have. Why is a management consulting firm a little bit more difficult than, say, a construction company? Well, because there's not many startup costs. With the construction company, you need bodies to do the work, you need employees, you need equipment that you have to purchase in advance. You likely need a commercial space, things like that. So you have to start to think, well, even if she were to have hired someone from the beginning, the only amount of the salary that counts towards the investment is what's paid up front. So yes, you can give someone a signing bonus of $20,000, let's say, and include that as part of your initial investment, but you're still paying that person $30,000 or $20,000, whatever it is. So these are all things you have to keep in mind. And the same is true with a commercial lease. So we did have a commercial lease for her. She did need office space, but she had to pay it all up front for a year in order for the full amount of the lease to count towards the investment. So the first thing we did, of course, was file with the state, the business with the state of California, since that's where she lived and wanted it to be located. She has secured a commercial lease. We showed that she paid with the wire. We did an articles of incorporation. She was able to secure a collaboration agreement with clients, some letters of intent to hire her. Once the E-2 was approved, she purchased domain names she came up with a company name, purchased domain names for the company, obtained any licenses and certifications, EIN number from the IRS. She's got she contracted for a brand and logo package. She started networking. So one of the things that we were able to show as part of her investment was, in her business, people like to schmooze and go out to dinners and drinks and whatnot, and it's a very person facing. I think that's the term. I think I'm screwing it up a little bit, but it's very interpersonal. So it's a lot about relationships and networking, and part of the reason that she was very confident this will succeed was that she has a lot of connections that she's made in her 15 plus years of experience that she plans to utilize. And then she was utilizing. So that's how she started to get people saying that, yeah, you get your visa approved, your company opens its doors. I want to hire you. We also got her a business plan, outlining the next 5 years, what that's going to look like, including the fact that she's going to go from just her to 5 employees within that time period. Keep all your sales receipts, even if you don't have, if it's a new business and you don't have a bank account yet, you're going to have to use your personal account until you open it. But that's money that still goes towards the investment. You want to keep track of everything. I highly recommend using a spreadsheet, Excel, something like that, to make it really super easy. So then she did open a bank account. We were able to put in that. And we did also have her personal account to highlight, here's all the times, she took a potential client out to dinner. She even traveled. She lives up north in California. She flew to LA to meet with a client. We put all of that in there. And what's also nice is your legal fee payment can count towards your investment as well. So of course we provided an invoice. So we had, as I said in the beginning, we had a limited amount of time to get this all in. So that was the basic evidence we submitted initially for investment and not marginal. Next requirement is that you have substantially and irrevocably committed the investment funds. So this means that you've already paid for things. Like, that's why I was talking about the salary for an employee. If you're saying I'm going to pay you $1,000 a month to be my employee, that's not irrevocable because you can fire the person at any time. But if you're saying, if I've already hired this person, I pay them a $20,000 signing bonus, well, that person's not going to give you the money back. And that's what you have to show, that it's substantial enough for the type of business that you're trying to open. So again, when you have a business like any business that can be really run remotely, so you don't need too much, like more than a computer and a phone, maybe a car, things like that, you have to sometimes get a little creative because you have to have a substantial investment, but it has to be relative to the business. So if she was trying to open a manufacturing company where you needed big machines that cost millions of dollars, putting in an investment of $50,000 is not going to cut it. But in this type of business, it does cut it because there really weren't too many costs. So we kind of had a push to think, okay, what else can we put towards your investment? What else is your business going to need, even if it's not immediate, but in the short term, what will your business need to be running? So, I couldn't read my notes. I think I got auto corrected. We opened the corporate account, and this is another good point. You open a corporate bank account. Let's say you transfer $50,000 into that bank account. That is not irrevocably committed to the business because it's your bank account. You could take the money out at any time. One thing you can do is actually put some money into an attorney trust account and have it the release conditioned on approval of the E-2. That's considered irrevocably committed. But essentially, you want to show that you're paying for things for the business to get started. And again, I am talking in terms of a startup business as opposed to buying a business, which we would have a very different conversation about. The next thing you have to do is show that you are in the position to direct and develop the business. And this usually requires you to show that you have a controlling interest in the company and that you're going to be in charge. You're going to be directing the company. You're the CEO, you're the president, whatever you want to call yourself. In this case, client had 100% ownership interest. 100% of the capital came from her. She's listed as the acting CEO. And we explained that her 15 plus years of experience in this exact industry is what gives her this ability to direct and control this type of business. And we did submit her resume along with a personal statement explaining all of this. And I did mention, I talked a little bit about lawful status, immigration status, when I was talking about the 60-day time period. One thing I neglected to say, and I apologize, was that part of the reason we care so much about it, yes, you have the 60-day grace period, but you're not going to be able to get an E-2, even if you leave the country, if you ever had unlawful status in the U.S. So part of the requirements here is to prove whether you're applying outside the U.S. or within the U.S., that any time spent in the U.S., you maintained lawful status. So those 60 days, that's what that went to. And then the last thing that you have to prove, this can often be the trickiest part, is source of funds. What that means, or source of capital, is that we have to show, where did you get this money from to start the business? We have to show that you got it from legal sources, income, gifts, sale of assets, personal loans that are collateralized. You have to be personally liable for the loans if you are taking a loan. And you have to trace it through wherever the money went. So if you have 5 bank accounts and you transfer the money through 5 bank accounts, every single bank account, every single bank statement where you can see that money transferred, we have to submit. And this can be hard depending on what you're dealing with. So in this case, our client's money, and I'm going to get into the source of capital in a little bit, for anyone who wanted to just see the basic overview of an E-2 is before I get into the more complicated discussion when I discuss the request for evidence. But essentially, In this case, we had stock options that were purchased and sold, and we had to explain the entire situation to USCIS, who are not necessarily financial experts. We did do premium processing, which this client did file before they changed the rules. It was before 15 calendar days. So it was 15 days from the day of that they received it. I think it was since April 1st, they changed that rule. Now it's 15 business days. So Saturdays and Sundays no longer count. So it takes a little bit longer to do premium processing and it costs more. That's the way it is sometimes. In my experience, whenever we file these E-2s, we tend to get requests for evidence or RFEs, no matter what we submit. A lot of times, these RFEs, I think they're a result of you submit so much documentation, they might not be seen fully. I don't know, but they do tend to come back and say, and to miss a lot of evidence we submitted, because they do list what you submitted and why it's not sufficient for each category. And once you do submit the response for the request for evidence, they then have 15 calendar days, now 15 business days again, to make a decision. So in this case, this was a very lengthy request for evidence. I've seen this a lot with E-2s. It can be frustrating, but we deal with it what we can. The first thing they said is, well, you didn't prove your non-immigrant history, or your invalid non-immigrant status. And we had to prove at the time of the filing that she which was within that 60-day time period, that it was within the 60-day time period. When we initially filed for her, we didn't have her last paycheck or her severance pay. So we weren't able to include that. So the last paycheck they had for her was sometime in November, because that was just the last one that we had. And it looked like her, even though, as I mentioned earlier, her work termination letter said your last day is, I think, was like November 27th or something. Just because it said that, USCIS wasn't like, okay, that's her last day. They're like, no, show us the paycheck. And her paycheck actually was dated after that. So technically her last day could be argued after that, but we got it in within the 60 days of whatever the job letter said. So we were good. But we did have to go back and explain this. Next, they wanted more evidence of the source of capital. Now, this is where it gets complicated. In this case, our client executed a same-day stock purchase agreement with her former employer. So, and I knew nothing about this until this case. I had to do a lot of learning on my own. Interesting. I didn't know necessarily how stock options at some of these companies work. But essentially, she was given stock options years back, and she could decide to exercise that option once they vested. They were fully vested already. And what she ended up doing is she never had any money come out of her pocket to make this purchase. And that's why it got confusing for USCIS. What she did was she had an option price for a certain number of stocks. She purchased that. At the same time, basically simultaneously, the company wanted to purchase back the stocks from her at what they called in their contract the purchase price. I don't know if it was the fair market value at the time, but it was a higher set price. So the same amount that she purchased, they were purchasing back. And basically the agreements, once I had to read all these different documents to understand it, that instead of her paying X amount, the company paying her X amount, there was going to be some math done, some subtraction. So they calculated the cost of her stock, the number of options she was exercising, the total, the aggregate amount of that, and the aggregate amount that it's going to cost the company, subtracted that. Then there was fees that, wire fees, taxes that had to be withheld. And then because this was an Israeli company, their bank was back in Israel, and the money that ended up going to my client had to then go through the exchange rate. And I actually talked to an exchange rate expert on this. So thank you to my expert if he's watching, who helped me out a little bit to understand how the exchange rates work. I had to find the bank's exchange rate on the day of the transaction, and I ended up getting a very close number because you have to show that, look, this is how she got the money, and here it is in her bank account now. And the numbers should be the same, right? Well, when you're dealing with exchange rates, it's not always the same unless you know the exact exchange rate, and all the exact fees taken out, which we didn't necessarily know. So it was a little complicated. And to add on top of that, because this company no longer existed, it was so hard to get some of the documents because we didn't have what we needed. And there really wasn't anyone there who was able to assist us with that. So it was really hard, honestly. And I was really happy when I figured out how it worked because it's not my area of expertise. We deal with finances for people all the time, but we're talking about some complicated like stock situations here. And then I figured that all out, and then like I said, you have to finish tracing the money through. So they put it in her checking account. She then transferred to her savings account, and eventually that money and some of that was transferred to the business's bank account when it was open. Some of that money she had used in the personal checking account towards the business before the bank account was open. But then I also saw that there was a loan back to the company, and then she received money back. A few months or a year later or something, she received the principal amount of the loan with a little bit of interest back. So I also had to explain that piece of it too, because if you took out that money, there wasn't enough for the investment. So it can get really tricky. And I probably butchered explaining that. I apologize. I hope it was clear, but the real key here is that when you're doing an E-2 visa, even if you're investing in a company or you're starting a company, one of the biggest things that you have to be aware of is you have to be able to trace the source of your funds from a legitimate source of income from its origin all the way up until it's being used for the company. And that could take a lot of steps. Next, they had an issue. The RFE wanted more evidence. Sorry, that's a better way to say it, on the capacity to direct and develop. And this can also be difficult for a startup, especially when you only have one employee to start. So we had to explain that, yes, she will be engaging in some unskilled labor. Probably, we estimated 5 to 8 hours a week. We listed the tasks that she would do and explained this is not going to last for very long. Part of the business plan says that before the end of this year, she will be hiring an administrative assistant to help her and to take over those unskilled labor tasks. But you also have to not just do skilled labor. Remember, you're supposed to, as the petitioner for an E-2, you're not supposed to be a regular employee. You're supposed to be the president. We have a question here, but I think it's off topic. Let me see. Hi, Amanda. Is it safe to travel using combo card, EAD with advanced parole? My wife has an old-time case, but we are married with a child, and I filed an I-130, I-45. Gaz, I will answer your question, but at the end, since it is a little off topic, but I will be happy to answer that. So for the capacity to direct and develop the company, we had to show them that she's going to also be supervising others. And there, at this point, we then put in a block and line organizational chart, proposed job duties for people, proposed dates of hire, levels of education, job descriptions, the whole 9 yards to show that this was really seriously thought out. We did, as I said, had a business plan. We actually updated it to include more information about how the business was going to progress. We re-referenced all the evidence that they left off the list and said, okay, see previously submitted exhibit blank for the articles of incorporation, for her first personal statement explaining her background and how she's going to direct the company, the collaboration agreements and letters of intent that had her name on it, signing as the agent for the company, and her resume detailing the exact experience needed to enable her to run such a firm. But we also included new evidence. Well, we updated her personal statement to give more details. We had a business amendment filing and statement of information for the corporation. I mentioned the block and line organizational chart, the proposed job duties, another letter of intent because people wanted, she was freaking out because people left and right wanted to hire her company and she couldn't start yet. So we were really rushing to get things done. But another thing I did, which maybe, I don't know how many other attorneys do it. This was the first time I did it in an E-2 filing, was I actually did some research on management consulting firms and what the startup costs look like, and what a startup management consulting firm looks like. So I did that because I wanted USCIS to see that what the steps she was taking were in line with what anyone would take in order to start such a company. I do think that helped. And then finally, they wanted more evidence on the investment in a bona fide enterprise. Again, this was all the evidence that the petitioner took to open the company's doors. And again, it was in the startup phase. So I mentioned a lot of this evidence already with updated business plan, personal statement, bank statements, credit cards, the branding package, the block and line organizational chart. We made a balance sheet to show all of the money that was spent and what it was spent on. We included the additional letter of intent. And we put that all together. I wrote a very extensive cover letter specifically explaining the source of capital because, as I said, I kind of summarized it, but it was a really complicated thing to understand. And you had to there was like multiple 20-page agreements, 20-plus page agreements. You had to go through and find these sections where it explained it and piece it together. That was why it was hard, but like I said, I was excited that I was able to figure it all out and get it done. And after we submitted it, I think it was less than a week, we got the approval notice and a huge sigh of relief across the board for everyone because now my client's been out of work since the end of last year. Now she can open her doors and start serving her very excited customers and watch her company grow. Now, her visa will be good until 2026. They give about 2 years, and she can renew it either by filing for a renewal or an extension in the US or by going out before her visa expires, getting it stamped, and then re-entering the country. Whew, that was a lot. Now, quickly, let me answer this question here. Is it safe is it safe to travel? The EAD card has nothing to do with the travel. It's just the advanced parole. If you have a valid advanced parole claim, and I'm assuming one of you, if your wife has an old asylum claim and you're married with a child, I'm assuming that you are a U.S. citizen or a permanent resident. If your wife is in removal proceedings or deportation proceedings, she can't leave the country. She isn't. Okay. So I'm getting a yes here. She needs to have her removal or deportation proceedings terminated or dismissed before she can leave with advanced parole. If she leaves now with no proceedings. Okay. Well, just so anyone listening out there, if you do have an advanced parole document, and you're in removal proceedings and you leave the country, you're deporting yourself. If she's not in proceedings, if she just hasn't had her asylum interview yet, then yes, she can. It's not a bad idea in that situation to withdraw the asylum application, depending on how long it's been pending, just in case she has an interview. Okay, so you're a citizen and she's never had an interview. Yes, so I mean, you don't have to withdraw the asylum application. Again, it would depend on. The only thing I'd be worried about is if she would have an interview while you're away. If you're only going away for a short period of time, there's nothing to worry about. We generally, unless the asylum application shouldn't have been filed in the first place, we generally tell people keep your options open. Don't said not to withdraw the asylum. So our lawyer said not to withdraw the asylum because she is out of status. Well, if you're a U.S. citizen, it doesn't matter that she's out of status, because there's an exception for immediate relatives, and immediate relative is one of the types of relationships is the spouse of a U.S. citizen. So, I'm not, unless there's something else I don't know, I don't see why withdrawing the asylum would be an issue. It would not affect her admissibility on the I-485. Definitely doesn't affect the I-130. If she already has the advanced parole document in her hand, even if it's the combo card, she has not just the approval notice, but the actual document, then she shouldn't have a problem. I advise discussing it with a lawyer in detail, because there are other considerations, just in general to give you an idea, such as if she's ever been arrested, she can have an issue. But is there any chance she can be denied entry? There is always a chance she can be denied entry. Until you are a U.S. citizen, there's a chance you can always be denied entry. Permanent residents usually are okay unless there's some type of criminal record, but anyone coming on advanced parole is never a guarantee. Although if there's no criminal history, no removal proceedings, anything like that, then in my experience, my clients have not had any issues. But the safest thing to do is to stay here until you get your green card. But if you do travel, shouldn't be an issue. Paying taxes is good. Having a daughter together is fantastic. Congratulations. That will definitely help your marriage case. So, Gaz, to answer your question in sum, yes, she can. Should you bring a lawyer? If you want to bring a lawyer on your trip, I don't know. That's not going to really help. If you're talking about bringing a lawyer to interview, different story. A lawyer letter. I mean, you can, but she only needs the advanced parole travel document. You can have the receipt notices for the I-485 or 9130 if you want as well. But I never write clients a lawyer letter. They don't need it. They're going to put in her A number in the system when she comes back in and see everything there. So, yes, she can travel. There's a possibility they can deny her reentry, but it sounds like from the facts you're giving me, which are limited, it doesn't sound like she'd have a problem. I know that was a little off topic from our E-2 discussion today, but I'm always happy to answer questions. If anyone else out there has any questions, you're very welcome. You can, our contact information is scrolling across the top of your screen. Give us a call, shoot us an email, be happy to help. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. If you found this video to be helpful or know someone who may, please hit that share button, that save button, drop us a comment, let us know what you like. And thank you all for watching and have a great day.